Okay, I rise to report that the forum was scheduled for the Senate Committee on Tourism, Arts, Culture, Youth and Sport to commence business.
Thank you, Secretary. Secretary will inform the chair that the Senate Committee on Tourism, Youth and Sport do have quorum to commence business. Those in for motion, can say aye. Those not in for the motion, say no. The ayes have it. We go straight to the agenda. Can we look at the agenda? If all of us are okay with the agenda, we can move the motion for that also on the agenda. You have this? Yes, I have. Can we move the motion for the agenda?
Some have to work.
Sorry?
We have two agendas. Thank you.
Yeah, I move the agenda to be as it is.
As it is, okay. Second there? Okay, second. Thank you very much. First of all, we have to apologize due to certain circumstances. Because some of the members also, they have this constituency engagements. At times they travel overnight to come and attend these meetings. So we are apologizing for any inconvenience. So we will start the process. So we can now start. We can take us through the question paper.
Introduction.
Sorry. All right. Because at our side, we introduce ourselves so that at least we can get familiar with each other. My name is Honorable Seguba, representing Basel constituency and chair of the Senate Committee Tourism, Arts and Culture and Youth and Sport.
Yes, I am Honorable Srinidha, a member for Riverside, and the same time member of the Select Committee.
Yes.
Good morning. I am Honorable Omar Jam, a member for Janjamure constituency and a member of this committee.
Good morning. I am Honorable Ali Ubalde, member for Jarvis and a member of the Senate Committee on Tourism, Arts and Culture and Youth and Sport.
Good morning. My name is Bafode Kyoto. I'm a subject matter specialist for this committee.
Chef Tijanian, subject matter specialist.
Good morning. I'm Honorable Baden Bosane, member for Fodi Bondage, part of the Select Committee.
I am Honorable Santure, member for Bakau constituency and a member for the Select Committee.
Senior legal
National Assembly.
Good morning. My name is Serin Bambajabi from Ministry of Justice, Senior State Council.
Good morning, everyone. I would like to release my name and the Registrar General responsible for intellectual property.
And since Sarah Eboya, clerk of the committee. Welcome.
Thanks.
So we can now go through the.
I need to put the mic on or?
Yes.
There's no need. Thank you. First, I also want to apologize. There's no need. Yes. First, that is concerning the invitation that was sent to us. We understand the invitation was dispatched sometime last week, but apparently our records received it yesterday. So that's why we could not come to attend to this meeting yesterday. So I'll take you through draft position paper per se. That is in the introduction concerning the need for having this law. Because, our current bill is, current law is 2007, that is the main act. And the amendment was 2015. So during the period, there has been a lot of changes in terms of law. Gambia, we are a member state of the African Regional Intellectual Property Organization and the world. So as recent as 2021, we joined the BANJUL protocol of ARIPO. And since it's ratified, it's important that we domesticate our laws. That's how they become effective or enforceable in our domestic laws. So that, in fact, is one of the reasons why we had to come up with the law. The idea started sometime in 2012 when we had a policy. We have an intellectual property policy, 2012-2023. The policy is what would guide our action on what we need to do as a country as far as intellectual property is concerned. So during the consultation process, it was realized that we need to come up with a new act that is comprehensive, all-encompassing, because intellectual property is in twofold. One is industrial property, which is patent, trademark, industrial design, and the other part is copyright and related right. And you may know the creative industry under copyright, which copyright has been having a lot of challenges. One main challenge is the issue of collecting society. Since because collecting society is established under the Act, which is Copyright Act 2005, but since its establishment, it has not been functional. They don't have an office, and one of the reasons was that, in fact, it was one man office. Mr. Sisi used to be, Hassan Sisi used to be head of copyright, and recently they had Mr. Sejawa. So as a result, the collecting society have been struggling. Okay? It's established because, in fact, one of the reasons why they've been having issues is how to implement or how to make the copyright society functional. I understand, even though it was established under the law, they went and they registered it as a company when it was already. So this means they've been ill-advised. There's limited capacity in terms of what they need to do in terms of law and capacity in copyright. So this, is one of the reasons also why we thought, we should come up with a bill. So I'll take you through the parts of the bill, the draft bill. First part is on the definition. Right? The definition part, since we are going to now merge the industrial property and copyright, there is a need to merge the two definitions. And also in anticipation of Gambia joining certain treaties, we thought it prudent to add certain relevant definitions. That is the first part. The second part is the establishment of the office. Now we thought establishment of the office now could be a national policy. Whether you want to place it under, in certain jurisdictions it's under trade because of its business dimension. In other countries it's under Ministry of Justice, right? In Gambia it's under, industrial property is under Ministry of Justice. In Sierra Leone, in Nigeria, and Ghana, they're all under Ministry of Justice. In other jurisdictions it's under trade. In other jurisdictions as well it's a semi-autonomous body that exists on its own. But you have to have some main ministry you report to. Nigeria, I think, is under trade. But generally, overall, is under Ministry of Justice. That is the practice. So we thought it prudent to place it under Ministry of Justice for few good reasons. One is that we have an automation system. Because, of course, when you want to administer rights, you have to have a system where you capture all rights, you have a database of recorders, because it could be based on national, regional, and international. So you must have a medium where you can lodge the information and be able to access it, which we have at the Ministry of Justice. As far as I know, Copyright Office or NCAC, they don't have that system. So this system started sometime and was donated to the Gambia sometime in 2012. That's when the data capture started. It was donated by the World Intellectual Property Company. It's called IPAS, Intellectual Property Automation System. So as a result, if there exists a database, it's good that we use it to administer the right. And also we have the capacity as a ministry. Previously we had 5 lawyers who had masters. So there is a program that is organized annually in Zimbabwe. It's called African University. So since, I studied in 2014, but prior to me, a former colleague who was the acting registrar when in 2013. He did masters, he was at Minister of Justice. I went and did my masters, came back, joined Minister of Justice. Our other colleagues, JT went there, came back, with other colleagues, Mr. Cisse. So we have that capacity in terms of intellectual property in general. So it helps when you have that lawyers with the masters in intellectual property to be able to administer the rights. It's a right issue. So understanding of the law and the technical area, or the subject matter is important. So that is why we decided that it should be under the Ministry of Justice. Going forward to issue the part 3 with regards to national treatment. National treatment is a principle that is provided for in a lot of conventions. One is the TRIPS, which Gambia is a signatory in the TRIPS agreement 1995. So it's a requirement that, in fact, countries should not discriminate against other nationals, in favor of. So unless it is procedural. So this is a principle that we have to have, in our laws. So that is why we started that. And then part 4 is regards to patent. Patent in the previous act. In the previous act, it was limited because we have certain standards. In our 2007 act, the duration of patent was 15 years, renewable 5 years. That means, we are lacking as far as that law is concerned. But in 2015, in the amendment, it was increased to 20. So that means in the 2007 law, it is 15, but still renewable 5 years. But in the 2015 amendment, it was increased to 20. Our minimum requirement as a country under the World Intellectual Property Organization, the Paris Convention of WIPO, and especially the TRIPS should be 20. That is minimum standard, international. So you can have 3 plus, you can have more duration, but generally it's just 20. So we thought that in fact it should be aligned with the international standard. And also, given the fact that Gambia is also a signatory of certain countries like the Harare Protocol of ARIPO, which protects patent, industrial design, and utility model. The minimum is 10 years, 20 years. So as a result, certain provisions were missing in the former laws, in the former acts. So as a result, now we decided to make it comprehensive to cover for all, treaties that the Gambia is a signatory to. Because it's important that when you sign treaties, you domesticate them. All right. So this is a way of domesticating treaties or principles for patent protection. Utility model is the next part. Utility model is like a petty patent. All right. This is an area that mostly African countries they are encouraged to utilize. All right. As far as our law is concerned, the duration for patent is silent in both laws, and it's important that we insert it there. It should be 10 years. The duration for utility model is 10 years, and Gambia too is a signatory to the Harare Protocol that protects also industrial design. So the next part is industrial design, even though it's an area that is not very used as far as African countries are concerned. This is something that deals with the appearance of products, the aesthetic look of products. This is useful for our fashion designers. Our fashion designers, this is the area that they can utilize. But as far as our law is concerned, this country, we don't have a detailed law concerning industrial design. So the next part is on trademark, which is the most common, right that African countries we utilize. As far as Gambia is concerned, annually the average we have is 300 local applications. Compared to the others, we don't have trademark application. Also, so as a result, we think this trademark system regime is key. Given that Gambia also is a signatory to the BANJUL protocol. We joined the BANJUL, in fact, it's National Assembly, same National Assembly that ratified the BANJUL protocol in 2021. So effective then November, Gambia joined it's a member of the BANJUL protocol. So we started receiving application, trademark application, as well as people started designating Gambia. So as a result, it's important that we domesticate the laws. There are certain provisions in the BANJUL protocol that were not found in our local laws. So we deem it necessary to now domesticate the provisions of BANJUL protocol, given that the Gambia is a signatory. So geographical indications. These are names that are attached on goods that have a unique quality because of the area they come from. This is an area that we never had laws on geographical indications. Certain countries like Ghana, Nigeria, Cameroon, they are using geographical indications. Recently, we in fact engaged FAO for supporting this area because we are thinking of having some products. Senegal, they have a law on this, and in fact they register the Kaba, Mat de Casamance. They use this law because for us, once we have this law on GI, we can join the Lisbon Treaty. So Senegal is a member of Lisbon, so they use Mat de Casamance, and they were able to generate in fact benefit to the local communities in a certain part of Casamance because of the mud. In fact, we thought of challenging it because mud Kaba is found in Gambia also. So we thought maybe we can challenge it to say, in fact, can we have cross-border GIs? But Gambia, we don't have GIs. If they tell, do you have law on GI? We tell them no. So it's good when we have this law on GI. But when we engaged WIPO this year, when we went there in July for discussion, they said, not every mud, not every Kaba that can be registered as a GI. Because there is a certain part of Casamance where, because of the soil there, the taste of the Kaba is so unique. So that is why they listeners know. So during the process, I told them, look, maybe Jamba Katam. We can register Jamba Katam. There are a lot of Jamba Katam in Gambia. But we thought, one time my sister mentioned that there's Jamba Katam from Kiang, because of maybe the hilly soil and everything, it's unique. So then all of a sudden I just mentioned that maybe we have tea. It's something that is not automatic, but once we join and have this law, they can come on the ground and do awareness creation and also a study, because they have people with that technical background. So once we have the laws, they can come and offer that technical, so that at least we identify unique products, even in the remotest country in the Gambia, so that at least if that product, wherever it's coming from, if they have to, the community will benefit. Provided it's unique. It's not every product that you can get. Last week I had a meeting with the traditional medicine practitioners. They were mentioning Mborbo. I said Mborbo, but Mborbo can be found in Senegal. But what type of Mborbo are we talking about? So GI is a good law that we as a country can benefit, provided we have something that is unique for Gambia. And it can benefit, it can be exported abroad. So we can use that unique name unique and name from maybe the region. Next part is on plant breeders. Plant breeders, we never had a law on plant breeders right. Even though in the Gambia they will tell as far as I know, we don't have a plant breeder. We only have one, Absa. But if you ask her, have you ever breeded any plants, she'll tell you no. She has the expertise in theory, but she has not breeded any plants. And this is agricultural thing. We have a lot of projects on agriculture, plants, seeds, but what are they doing? So, but it's important that we have a law on that. So that is a good step. When we start to have the law on plant breeders, right, then we can explore whether Gambia we can have breeders. If they are able to breed plants, then they are entitled to their right, and they will be protected under the law. So the next part is on traditional knowledge, genetic resources. This is an area that in fact has been discussed for over 20 years at the World Intellectual Property organization level, because it is believed that it's an area in which Africa and Asia have a comparative advantage because of our knowledge, our traditional knowledge and genetic resources. But unfortunately, the developed countries, they are not supporting the passing of the convention because of their own interest. But as recent as last year, it was concluded, it was resolved at the World Intellectual Property level, organizational level, that there should be a convention on traditional medicine, traditional knowledge. So this is an area, we never had law on traditional knowledge, so we think we should take the opportunity and enforce it. Even though Gambia is a member state of the SOCOMON, there's this protocol at AHIPO. We joined in 2015, but we haven't domesticated the SOCOMON protocol on traditional knowledge, traditional cultural experience, and genetic resources. So we believe we should have a law on that. The next part is copyright and related right. This part was, like I said, was in a standalone act. So we think now that we are going to have one law on intellectual property to encompass both intellectual property and copyright. We should have one law. So now, so that at least we have one right. And also, we anticipated that we're going to accede to certain protocols. One is the WCT, World Copyright Treaty of WIPO, and the WPPT of Performance and Phonogram, and the Beijing Treaty, and also in 2022, myself and the minister, we went to Uganda, during which we negotiated this Kampala Protocol, ARIPO Kampala Protocol on copyright and voluntary distribution of copyright and related rights, which we signed. So it's important that after signing, we need to, once it's needed to be ratified. But the most important is the domestication part. So as a way of domesticating these treaties that we signed on copyright and related rights, we thought we should now use the opportunity. So the next part is enforcement. What is the need for registration if you cannot enforce your rights? So we believe previously the enforcement part is not too comprehensive. As a result, now we want to make it so comprehensive and give the whatever legal backing that is required under the law. The police, we've been working with the police. In fact, we provided training for them. And we have a unit called Police IP Office Unit that in fact benefited from USPTO. They had some training. So as far as police enforcement capacity is concerned, they exist, even though it's maybe minimal, but they have some training. So we believe when we have the laws and then capacity as far as police is concerned, they will be able to enforce rights. Because there's no point in, because if I tell you 95% of our applications are abroad from international applications. So that means people who have interest in covering their rights in Gambia. So there's no point in them spending money when in fact when the rights are infringed on the ground, we cannot enforce it. First, we need to have the laws. Once we have the laws in place, they too, because they are investors. So if we don't have the necessary capacity, they can support it, provided the law is there. So this is something that we thought we should, in fact, use the opportunity. So also, because the next part is the civil remedies. Civil remedies of intellectual property, because intellectual property is generally civil in nature. It's generally civil in nature. So if it is civil in nature, we must have the remedies available. And that's why that part deals with the civil remedies as well. So that is part of the bill. With regards to consultation, we did a lot of consultation as far before we finalized this bill. We had a consultant that was engaged by WIPO to help us with the whole process. So we did that, and then we validated it. We validated sometime in 2021. Prior to that, in fact, it was the cabinet that approved it. So also we forwarded it to copyright area, because copyright is not on our domain. So we forwarded it to NCAC. We had, in fact, support from EU. So as a result, they subjected to 2 validation exercises. So as far as this bill is concerned, it was scrutinized by both the stakeholders as far as industrial property is concerned, as well as copyright. In fact, for copyright, it was Council Jibril, who was the consultant, Council Jibril Ba, who was helping the NCAC to review it. So as far as this bill is concerned, it was reviewed or validated 3 times. One under the Ministry of Justice, and twice under the NCAC. So that's it for part. Thank you.
So members, I think the ministry have to go through.
Sorry, I mean, you will excuse my write-up because something like that was a draft and yesterday I was on road. So I thought cannot just excuse by not sending it. So I had to. So it was not reviewed finally. So you excuse our titles. Okay. Yes. Yeah.
Yes. Honorable.
Yeah, thank you, Honorable Chair. I thank you very much for your explanation. I am very much convinced with your explanation, but I have a feeling with the naming of the bill. Seeing the intellectual property bill and going through the bill does not deal with intellectuals. It doesn't deal with intellectuals. This is my understanding. So I want you to make me understand why the name intellectual property bill.
Thank you, Honorable. The term intellectual property means creation of the mind. So it doesn't mean you must be educated also. So anything that you create, like using your human mind, you deserve to be protected under this law. So if you are a business person and you come up with this spore, like this snow written here, someone manufactured it and is selling it. So this snow is called, this snow is called a trademark because it's something on value and you invested a lot of resources and time to come up with it. So it's important that you put it there to distinguish your product with that of others. So if it is patent, it's an invention. Invention is not easy. If I tell you Gambia, we have 0 invention. They exist, but we don't have invention register. So as if people spend time or they are talented with that knowledge and they come up with an invention, if it is this mic is an invention, AC, anything, everything you see is intellectual property. The seat I am sitting on is intellectual property. Someone created it and make it comfortable, which is different from whatever others, because they are different. Right. So it's like an invention, make it easy for yourself. So it's like any time that someone uses his intellect, his or her intellect, to come up with something that is value, that the public will use, it's expected that, in fact, the person will be rewarded and protected for a period, not forever, for a limited period. So that at least the person, whatever investment the person invests in, can recoup it and also be rewarded financially. So that is why it's called intellectual. So it has a lot of dimensions. Thank you.
Mr. Chair. Chair?
Yes, one minute.
No.
Yes, Honorable.
Yeah. Okay, thank you. Again, maybe in your explanation, in terms that you are using, we are not legal experts. So just explain on our same wavelength. Because I am Honorable Chair. I have gone through it when whether these stakeholders that you have mentioned on your position paper, are they consulted?
Are they consulted?
Are they consulted on this?
Yes. They consulted. In fact, we have a intellectual property council comprised of all the stakeholders. NCAC is there, Chamber of Commerce is there, GAIPA is there, Judiciary is there, GRA is there, Higher Education and Competition Commission. They are council level. But as far as consultation is concerned, we consulted them during the drafting process and validation. During the whole process, they were consulted.
And what was their position on this?
They agreed, they all had agreed. There was consensus that in fact there's a need to have this bill.
Okay. Yes. 1 minute.
Okay, thank you so much. Trademarks. Sorry. Mr. Collier? Yeah. On this place, trademarks. Yeah. Like you mentioned Maga Kaba.
Yeah.
Yeah, so I don't understand that part very well.
Maga Kaba.
Yeah, so the trademark actually, you know. So
Yes. So Manga Kaba.
Yes. You mentioned something like that.
No, that is just geographical indication.
Okay.
Geographical indication, yes. This is something that, in fact, we want to now encourage as a country. Because we have a lot of potential. Maybe our mango, juru, maybe. There are a lot of things that can be used as a GI. GI means geographical indication. It is something that you use a name to denote that, in fact, this product is so unique and has a special quality because of the area it comes from. Right? It could be in any form. Kaba, like Senegal, they registered as a GI. Mad de Kasama, they call it Mad de Kasama. And every year you go, since they, year before mad. Like Senegal, all of call it mad, but we call it Kaba.
Okay.
You know. So, Kaba. No, not the fruit, wild fruit. It's so
no. I'll give him a very good example.
He knows it.
Okay. So that is something that Senegal has registered. Because Senegal, they always, because they have the laws. We never had the laws, So they had the laws, they joined the treaty. So resolution, they sought for a technical assistance. So they're able to get this Kaba registered as a GI. And it's helping that the community, people go there and whatever benefit is done, it's a percentage is given back to them. So on top of my head, because we wanted to challenge it, because cross-border is possible. Since Kaba is also found in Gambia, we thought maybe we can challenge it that now, whatever benefits Senegal are having, we too should have. But their advice was that, in fact, Gambia, can you think of something that you can register that is unique for Gambia? So I had to come up with a name, So I mentioned this Jambakata. Jambakata is found in a lot of, but if they tell you Jambakata from Kia, if we have, whatever is claimed that in fact it has that unique quality is there, you can register it. So it's going to now, we are going to engage the communities there, the women, especially women, to tell them like, can you harvest it? So probably maybe there could be a project to say harvesting of, now because you have to form as an association. It's not, so you have to, because, so some of them maybe they have the knowledge of how to harvest it, what time and where to put it. Maybe during the evening you harvest it and then you put it under a shade, maybe a cold place until after a few days if it dries, and how many days. These are all knowledge that our people may have. So because maybe if you have it because 3 years ago we went to Kia, we were hosted, lodged in a place, and the old man was telling me, because he hung me somewhere on the roof of his house. He was telling me, this is good. If you use this, you never be impotent. You can marry until the time of death. So those things, maybe not even the medicinal part of it, but maybe the taste. Because of the area it was having, maybe because Kiang mainly is hilly. I mentioned hilly, someone said not even knew me. There is a unique
Kiang is the bad side of the country, so that could go to the
So I said so that is GI. Maybe we don't know of other countries. Maybe our bush, rich area, like maybe Foni. There could be something that can be harvested there. And because it only emanates from Foni, you can have it registered as a GI, and then in turn, once they encourage local communities, especially the women, to harvest it, and because of the training they're going to have, it's a lot. Even like in Botswana, last year, WIPO supported a project. Even weaving of basket, because here now people don't weave this sound down. In Botswana, they have this weaving, their basket. The Koreans came. They bought a lot of containers from them, and they paid them. If you empower local women who cannot have certain means, you support them. So these are projects that once we have the laws, and we can seek that, because when you have the laws, then you can seek for assistance. Tell them, look, we have awareness creation. So So once they're on the ground, they study whatever we have, they can support us in a lot of ways. Yeah, thank you.
Thank you, Chair, and thank you, Mr. Colin, for that wonderful explanation. I think we're now getting the picture, more especially of the missing aspects of the draft bill. However, I just want us to cross-check a few things, more especially with which institution is going to host the new office. More especially knowing fully that there was an act like the 2014 Act, if my mind can serve me well. And out of that act, there was an office established through the National Center for Arts and Culture. And from your explanation, if I could hear you well, or if I heard you well, you did say as much as that office is established, it seems the capacity isn't there for them to give what is expected, which also brought about the drafting of a new bill in order to cover up those gaps. And from what we have from the draft, I believe from your explanation as well, you did said it is the Ministry of Justice that you think should host the new office. For me, because it seems from the 2014 Established Act, the Ministry of Justice as a legal institution seems to understand what the gaps were, what the problems were. But then it seems you don't try to remedy it until now, when you think you could come up with a new office. So it seems from 2014 to now, that gap has been there, and the players in the industry have not been really reaping from the benefits or, being really playing that unique role in order to ensure that the intellectual property bill is active and operational. If I may ask, having to get this new bill, don't you think even with the Ministry of Justice we might experience the same or similar problem? That is just one part of my question. My other question is, you said in other countries, the IP is always under the Ministry of Justice or Ministry of Trade, or at some point they are semi-autonomous institutions. Out of these three, from your personal point of view, do you think it will be possible to have the IP as a semi-autonomous institution, considering what their functions are going to be, in order to separate them from either that executive influence or other influences that might jeopardize their work? I just think, I would need a clarity on that. And on the consultation aspect of it, having the collecting society as an institution that was also established by law, what do you think were upholding their operations? Because for me, if you establish something as a law, there shouldn't be no strings attached or no challenges attached that would exempt from operating. Do you think this particular draft bill would help to address those problems? Because for me, making laws is one thing, but also enforcing them is another thing. And we need to be clear whether if we have this as a law would help to address those problems. Thank you.
Thank you, Madam. So I'll start with the first issue you raised concerning the problems. As far as industrial property is concerned, the first law was 2007. And the 2015 was the amendment, that is for industrial property. So as far as industrial property is concerned, we don't have any challenges. Even though we have limited personnel in terms of staff who will be responsible for various aspects of registration process. That's the only challenge, that is capacity. mean, there is a number of personnel. But as far as work is concerned, we are on top of things. So this is the first aspect. But concerning the copyright is where the problem was. Problem because one is because they did not have capacity. The law was there, but in fact, it was Mr. Cisse, the only two Cisse, who were doing it, and Omar Jallo. In fact, I was offering assisting them during the period, but mainly because they didn't have capacity as far as the area of copyright is concerned. Because these are technical areas that you need to at least have also the manpower, right? People with capacity and personnel to support the institutions. You are not expected to only limit yourself to office work. You need to reach out and support the stakeholders because you are the focal point as far as international organizations are concerned. So if they go through you to extend assistance to the stakeholder beneficiary and you don't have the capacity or you don't have the manpower, then there will be no direct benefit to our creative industries in the Gambia. So that is why now that we have the capacity, we think we are in a position to assist. In fact, now the two offices are going to merge. We are not going to abandon the office. They're going to move over. Because prior to 2005, 2004, it used to be on the Ministry of Justice. Because we did not have any person with the knowledge in intellectual property. But from 2013 to date, everywhere we have two candidates who are sponsored by WIPO or ARIPO to do masters in intellectual property. So as we speak, the capacity, I think we are now up to 10, people who did masters in intellectual property. And we have this group and then we work together as a team. So as far as problem is concerned, it's only on the part of copyright. Concerning the issue of housing the office, I think Ministry of Justice is, because intellectual property is generally, legal and business, So if it's not housed, unless we want to house it on the Ministry of Trade, because as we speak, we have the infrastructure, existing at the Ministry of Justice. So it's better that we continue, so that we don't reinvent the wheel. Systems that started since 2012, and then it's grown to.
I think having a new office is reinventing the wheel, not the other side.
Yes, now having a new office, because it's going to continue, because there exists an industrial property already. So the system is like going to continue. Instead of calling it industrial property, it's going to be intellectual property, because now we're going to merge the copyright. So as far as we are concerned, we have the systems in place, which is functional, and it's linked with the international systems. Okay, it's linked with the system of WIPO and ARIPO. So then now, once I sit on my desk, I can log in WIPO system to now download all designations for Gambia, which these people, copyright office don't have. So as far as capacity, now it's just the copyright office, they only have one individual, Mr. Jawara. He did it. He also eventually was able to pass the MIP, the masters, just I think last year. So, but for us, we have 5 lawyers, and then also we have legal clerks who have been trained in the IP since 2010. Okay, we have like 7 legal clerks, senior legal clerks, who, if you invite them, they can tell you from A to Z as far as intellectual property is concerned. Maybe some of them know better than certain things that we may not know. So we have the capacity at the Ministry of Justice. That's why I think it should be placed on the Ministry of Justice. The second aspect, whether in fact you can have autonomous, semi-autonomous institutions. That was the idea when we were negotiating the policy. That was the suggestion of the consultant to say, can you have it as a semi-autonomous, like Botswana have, what do you call it, Tanzania have a semi-autonomous thing, Namibia too, and Uganda, they have semi-autonomous, but it's a process. We think, as far as our country we are concerned, we should still stay on the Ministry of Justice until such a point that now we have that more capacity, and then we have the resources to have a standing loan institution called Intellectual Property Office for the Gambia, then we can move to a semi-autonomous. But as far as this is concerned, this is something that we've engaged the stakeholders, and we said, no, what, we should continue as office under Ministry of Justice. So that is for the second issue. Concerning the issue of collecting society.
Sorry, can I observe? Is it semi-autonomous to stand alone, or you want it to be under the ministry?
No, we want to be under the ministry for now.
He said the previous advice to them was for it to be a semi-autonomous institution.
Yes.
And I think before he go further, that's where we need a follow-up question.
Yeah.
Because you said in the process, the advice from the consultant was to have it as a semi-autonomous institution. But along the process, you would think it would be better to have it under the Ministry of Justice. What really convinced you to think in that line?
One is the issue of funding. Right, funding, because you need to have an office separate, distinct from the ministry, and they need to have the board. Because of course you need to, like NATIB. NATIB was has a board, but so it's been a process. So we think it's not the time is not now for us to have a standing or semi-autonomous office for now, because it's of funding, and then we need to have these laws now. So maybe in the near future, if we think it's time, then we can have a semi-institution. But as far as we are concerned, this is something that we too, at the initial stage, we are convinced that we should have. But
they gave the funds. I don't think funding should be a problem. Come December, they might provide you with the required funds to establish a semi-autonomous institution, just like the National Youth Council or the National Sport Council, and still it will be answerable to the Ministry of Justice in order to make the institution vibrant and as well as responsive to the needs of the players. Because I think we also need to consider that having a whole ministry responsible for legal proceedings and everything, if you want to kind of establish an office to look at IP, maybe priority might overshadow the operations of the IP office. But having it as a semi-autonomous institution and also, getting the subvention from the Ministry of Justice or from the Ministry of Trade or from whatever ministry, for me, I would think, that should be our direction. But then having to say that we don't have the money or the funds, having WIPO and all other organizations, the European Union, if they can be convinced that it can really have that monetary impact on our economy, I believe it can definitely attract funding. Because it's one key challenge that our young people who are in the music industry, in the arts industry, in the creative industry, are facing serious challenges.
I think, like I said, it's something that was really considered. But I think it's a good idea. That is the trend for especially African countries. Now people are going for semi-autonomous. As a ministry, this is something that we discussed, especially at policy level. We thought, no, let's not go for semi-autonomous for now. But it's a great idea that, in fact, now if you have a dedicated office just for intellectual property, then you will not be bothered with other legal issues. You only focus on supporting the system. We have multiple stakeholders and can have a great impact as far as our economy is concerned. Let's say for the issue of collecting society. If I tell you, our artists are not receiving any royalties abroad. So one reason is that this collecting society is not functional. They are supposed to be paying, receiving royalties internationally because they have that relationship. There is this system called WIPO Connect that, in fact, institutions can be able to detect, how many, music or royalties is due to the country from abroad. It's not respected, but abroad, America, Europe is respected and they pay. Even if you are a hotel owner, if you own a restaurant, even if in certain countries, even like Zimbabwe, if you have a car if you have a radio in your car, there's a certain token you pay as royalties. It's not free. If you play Jaliba music, play Estes music, in the food, even any public place, you're supposed to pay something. But if you tell Gambians that you are supposed to pay, they'll tell you no, because that awareness is lacking. But you are supposed to pay. I agree. I mean, if that is, we stand guided by honorable members. If you think we should go for semi-autonomous,
we have the legal department. They will also advise us later.
Yeah.
Mr. Kaba and the team.
Okay.
Apart from the funding, because most of your argument or the reason why you said you want to be semi-autonomous is about funding and maybe capacity-wise. But don't you think some of the officials you recommend can be in secondment to serve that semi-autonomous office until their members is being capacitated? Because if they stand alone, because right now you mentioned the reason why the copyright did not function well at NCAC is because they are concentrating more on the other areas than the copyright system. Again, it can be historically repeat itself. It can be under the ministry, and the ministry might be concentrating more on the other side. And because it's going to be overseen by the Registrar General, not so. And he might have a lot of other activities or assignments and foregoing the IP. So we think it is prudent for it to be standalone and semi-autonomous, whereby it will serve its purpose. If it is about the capacity or the resource, human resource, I think because you own the bill, you can support the establishment of the office, both in human resources, and if it is about capital or funding, that is the responsibility of the parliament. It's just about making them semi-autonomous and create the avenue for them so that they can get the funding directly. Because most of the institutions here who are semi-autonomous, they are now doing well. It's just the beginning, they will have some problems, but along the way, they will train their staff how to be at least more successful in their operations. But we thought, based on even the consultant, did he tell you the merits and the merits of making it to be semi-autonomous?
Mainly, it's about this concentration that is, because you cannot finish work as far as intellectual property is concerned. You have a lot of stakeholders that you need to support. So that's why he thinks if you have a dedicated office just for intellectual property, then you serve its purpose and benefit the stakeholders. Yeah. But as a ministry, like I said, this was our, but I would say let's not move to that level and let's stay here until, because we are able, now we don't have a lot of issues as far as our work is concerned. We have 7 staff, but we were doing it effectively. We don't have any backlog or challenge in terms of discharging our mandate. So for copyright to, is something it has. So maybe even if they should move and join us, we need more capacity in the copyright area. In fact, we've solicited support. USPTO, they are sponsoring 3 candidates to do some degree in copyright and related right, just in anticipation of having this bill passed, so that at least we support the institution, especially copyright. And there will be another training in November too in Geneva on copyright and related right, so that at least we build that capacity once we have it. So once, even we should stay under the Ministry of Justice. Once the system moves, we are not going to have more capacity in the area of copyright and related right. So I don't think we will have any challenge in discharging our mandate, even if we should stay under the Ministry of Justice.
Okay, sir. Oh, somebody want to comment?
Yes,
you want to throw more light on it? Yes, you can come.
Thank you very much, Honorable Chair, and the honorable members here present.
Can you introduce yourself?
My name is Kisima Bize from Ministry of Justice under the Legislative Drafting Department. I heard of the gentleman's questions that he raised.
Honorable
Jabi, right?
Jabi. Yes. We are understanding.
And then the suggestion coming from the chair, as well as the explanation given by Leonard Chile. I just want to clarify one thing from the bill. We need to understand from the bill that this particular office is not going to be sessioned under Ministry of Justice, looking at the provisions of the law. It is going to be an independent body. This is why, if you look at it under Section 3, it established the office. That's just a nomenclature. And it doesn't only stop at that, but it also establishes it as a corporate body. A corporate body means it's going to be serving as an agent that have the right to sue and be sued in its corporate name. So that shows that it's going to be an autonomous body, regardless of the nomenclature of the office. That is the intention of the agent. So I was thinking, when that is the case, looking at the write-up here, our thinking now should be, we should have an oversight body, like what he is suggesting. We should supposed to have a board that is going to serve as an oversight body, that is going to approve certain policy decisions. You get the point? So that's very important. So because it seems like the understanding is that this particular body is going to be under Ministry of Justice as an office, but that intention is not reflected in the bill. So it's exactly. So I was thinking, if the members are agreeing to the fact, they are suggesting that we need to have an autonomous body, and that's the advice from the consultant, and this was approved by the cabinet before it comes here. Now we think of creating a board that is serving as an oversight body, or else you're going to have a kind of a proposal again, making a suggestion to them that they, instead of having as an autonomous body, we're now going to create it as an office within the Ministry of Justice. Yes, that needs to be clear.
That is the idea.
That's the idea. And then do away with the autonomous nature of what is created in the middle. Yes.
Yes. Okay. Maybe I have to react to what he said. In fact, to ask you, probably I think Mr. Ture, huh? Mr. Koli, okay, good. So with regards to the IP bill, I know these things don't come out of the blue. Because when you initiated to have the intellectual property bill in the Gambia, I don't know whether you are aware, probably you must have done some benchmarking to understand some of the countries that are doing the intellectual property. Can you tell us what are some of the stories that how are they implementing it? At least we want to have an idea, because he said something that is very important in the bill, and we have seen that. But if you look at the position paper, probably I think you're saying it has to be an office under the Minister of Justice. And that was not what we were thinking. We were thinking like the intellectual property should be kind of an agency of its own. It has to be an office of its own and an independent body that is going to look after a whole lot of things in the Gambia. But I know you must have seen, you know, those responsible must have seen this somewhere. Can you share that with us?
Yes, thank you, Honorable. Let me start with the issue of idea of having, whether in fact semi-autonomous. This is something that I said the consultant, raised. But when we engage stakeholders, they think we should still remain on the ministry, and at the ministry level, we should remain on the ministry as well. When we went to cabinet, for cabinet conclusion, this was a suggestion, but cabinet think we should still remain under the Ministry of Justice. As far as experiences is concerned, for Sierra Leone, it's still under their ministry. Ministry of Justice. Okay. All right. Ghana too, they have a semi-autonomous. In fact, we are a member state, and like I can tell you, 19 registrars, how they operate and their experience is like, because we have that relationship. But it depends on the country.
The countries you quoted here, you want to know how, as he said.
Yes, so for Sierra Leone is still under the ministry.
Justice.
Ministry of Justice. For Ghana, it was under the Ministry of Justice, but now they have their own office. Semi-autonomous. Okay. Right. As far as Nigeria is concerned, it's also semi-autonomous. Yes, semi-autonomous under Ministry of Trade.
Yes.
All right. So as far as the other country, Sierra Leone is Ministry of Justice. Ghana, Botswana is semi-autonomous. Botswana is semi-autonomous. Namibia is semi-autonomous. All right. Uganda is semi-autonomous. Yes. So as far as these countries are concerned, they may be semi-autonomous.
Perhaps I was just going, because it's important.
Yeah.
For me, I know we have the Copyright Act in the Gambia before.
Yeah.
If I am aware, or unless if I am wrong, this is the first time we have intellectual property in the Gambia. 2005. So enacting a law for intellectual property in the Gambia for me, I think enough for members of parliament to be engaged before. Because you said something here, that you have done a lot of consultation with stakeholders. And you have done your validation. So you have a bill already that is brought before parliament. But this is the first time we're seeing it with no idea about the bill. You understand? So I think it's important for us to start from that end too. Kind of the bill is being rushed to us, for us to look at it and then pass it. But I'm not sure it can go like that. It will be difficult because a lot of things in the bill, even our experts, need to know a lot of the bill. And we need to sit with them. And also the countries that are implementing the bill, the semi-autonomous and then those that are working under the ministry, those benchmarkings are important. You understand? I know whether you have done it or not, that would have helped us to take some decision and know exactly how do we work with intellectual property bill. Of course, we will take the decision, but we're also going to rely on our experts to tell us what are some of the things that we need to do. You understand? That is our job. So for me, that is it.
Yes, sir.
Yes. People are also trying to check the semi-autonomous. I think it would have better that coming to under the Ministry of Justice. And again, I was looking on the bill, Mr. Bide, and can you kindly guide us through which provisions that stipulate this act, if it's passed, it has to be a body separate.
That's Section 3.
Section 3.
Section 3 establishes the office. Not only that, it's telling you that it shall be a body corporate, meaning it's a legal entity that can sue and be sued in its corporate name. It can enter into contract, can own property, it can do so many things on its own, like an independent person.
Yeah, of course, I have seen it, and that's part 2.
Yeah. So the only lacuna I saw, if you establish such an independent, you need to have an oversight, internal oversight, like a board, or some in security sector they call it a council. That is going to sit on certain policy decisions.
Yes, we have a council, but in this case, it's just to amend maybe the part 2. And then say it's established under the Ministry of Justice.
I'm very flawed. Mr. Bide.
Yes, sir.
But again, if you go to the preliminary provisions, where we have such titles, applications, part 2, the establishment of Gambia Intellectual Property Office.
Yes.
There you have mentioned the oversight body, that's the board. It's not mentioned there, and in the act, I think it's mentioned.
Yeah, that's what I'm saying. That's the lacuna, that's the gap.
Yes.
Very well.
That's the gap, that's what I'm missing.
Very well, very well. Yes, thank you.
So now to simplify the work, we forget doing that. It should not be simple. We want to place it already.
Yes, Honorable.
So it's better we correct.
Yeah, let's
Let that be on.
Can you note it down?
Yes.
Yes, Honorable.
Yes, thank you very much, Honorable Chair. Excuse me. I'm not sure of the content of the bill, but can you guide us as experts? Is there any provision where it caters for family members who lost their loved ones, say an Islamic scholar like the late Bunjem? We all understand that there are recording studios who are making money out of his preachers. So is there any provision that saves the family of such people like?
Yes, in fact, that copyright aspect it covers it. In fact, it's 50 years after the demise of the owner of the author. I mean, after 50 years after its person's demise. So whatever benefit royalties are due to be paid to the owner should be paid to the family members. So whether in fact there should be an administrator to do that. But like I said, there are a lot of royalties that are due to our creative industry here, but it's not being collected. But the good thing is that anytime that because if it is collected, it's kept in trust, wherever it is. So once we have a functional office, all you need to do is now communicate to the various institutions to say, do you have any funds held in trust for our benefit, for our stakeholder? They tell you yes. So if Gambians, we have something maybe for maybe American artists, whatever we have here, sometimes you just deduct whatever you do, then they send the rest to our account, dedicated account. So the good thing is that once we have an established office, they only need to use 20% of the funds, and the rest they give it to our artists, our authors. So the answer is yes, the law is there, and then even if you die, that's when in fact it will start to count, your benefits. So it's like a good legacy for our artists. Musangom and others, if I tell you, if one should ask, I'm sure he has a beneficiary in the Gambia. Maybe Senegal they are very functional, their collection is functional. Yes, in fact, I know few artists in Gambia that received royalties from Senegal. They went and registered there. It's voluntary registered, if they are registered, but for us, the law established that we should become, they give you, license, license to now collect on their behalf. So you contact, there are a lot of institutions that are doing that. They collect the funds and keep it. They are not losing now. Whatever funds that is collected is kept somewhere. So once they have the office will communicate to them and they will send the money. You'll be surprised within maybe a year, the funds will be in millions. And then it's up to the office now to sit and decide. Because there's a means now, it's called a WIPO Connect, means to detect how much is due. Because you cannot just share them among them equally. Some are more prominent than the others, the music plays. So they tell you basis to pay that, and then that's it. So the answer is yes, there exists a law.
Yes. Mr. Billy.
Mr. Billy.
Yes, sir. Thank you, because you have highlighted on my next question, because this is the reason. For me, I was thinking we need a semi-autonomous institution. For the fact that I think we need a structure that can have an oversight over the office, being it a council, being it a board, one might call it. That is the board of directors. And in this situation, for me, looking at section 7, which is appointment and duties of the Registrar General or the organizational structure. Okay, section 7, of course. Yes. For example, it says the registrar shall be appointed by the Public Service Commission in consultation with the minister. And for me, these are some of the issues I have around this. You look at other councils, it will say, let's say a particular ministry or so would appoint in consultation with the board of directors or board chair, just to make things balanced, because our laws sometimes need to be progressive. We don't just need to make laws and put ourselves in that tight corner, because tomorrow nobody knows. For example, I might be the president next 5 years, and I don't have interest in intellectual bills. And having a law that actually restricts the progress of that particular, institution, I might not really support it. So I think it's important we bring in laws that would really flourish what we are doing than putting on stagnant.
How can you reach yourself this law?
Yeah, exactly.
Can I highlight of what you have just stated? I think that's also important. If the law creates a particular body as a corporate body, and we are assuming that it's an agency, by virtue of this Constitution 175, it's the president now who now appoints in consultation with the PSC. But here I'm seeing the PSC now appointed, which is now reflecting technically their intention. But I think they need to clear it up.
Yeah.
Yes, that needs to be very clear. Because they are assuming that it is going to be just an office within the Ministry of Justice. And the appointment will be done by PSC. PSC normally does that. But here, the law creates the office as an autonomous body. So obviously, It's the president that's supposed to appoint the head of that body
Exactly.
in consultation with the
That's
peers.
what the law says.
I think we can just walk around.
Yes,
Thank you very much, Honorable. First, I should wish Honorable Jammeh good luck in his presidential aspiration.
That you'll be the justice minister.
I have seen a lot of issues with the bill, actually, a lot of drafting issues, but I think I will confine myself for now to parts. Is it part two? Part two, which we are discussing. The paper here, the rationale, is in conflict with what is in the bill.
I pointed that.
By their own admission, Cabinet has not approved setting up of an office as a semi-autonomous or whatever body. So the policy directive from Cabinet is that they remain under the Ministry of Justice. So I think it's a sterile discussion to be discussing about them being semi-autonomous. I think also I agree with my colleague, Mr. Bite, that if it were to be a semi-autonomous body, it should have a governing board. But there's an even greater problem than that one, which they have not noticed. The bill does not provide for how, if it were an office, it was going to be funded. There are no provisions, financial provisions, no reporting provisions. So even if you were to decide that it should be semi-autonomous or whatever, you will not only be going against what Cabinet has said, which is why I would suggest that committees in future should be asking the ministries to submit the Cabinet conclusions.
Yes.
So that you know what Cabinet, because Cabinet, I have written Cabinet papers myself before, and you ask Cabinet to approve not only the policy behind the bill, but that the bill be tabled before the Assembly and blah, blah, blah. So Cabinet will say, we agree with this or we don't agree with this, that kind of thing. So you should know what Cabinet has approved.
Yes.
Because the ministry is not in a position, otherwise they will not go to Cabinet. The ministry is not in a position to sidetrack what Cabinet has approved or disapproved and come to the National Assembly with their own agenda. So there are no provisions there. We don't know how it's going to be funded. That's a very serious lacuna, and you have to be careful of creating a new charge on the consolidated fund when Cabinet has not approved. So I think for now, part 2 may have to be reworked in that line, unless Cabinet approves it, which means that they have instructed the Minister of Finance to think about how they are going to do, even if it's the initial funding and the like. Otherwise, we'll be in some trouble there. You would have passed it and created an office with no funding, or no recognized. I'm not even going to discuss about the administrative arrangement because it's a bit confused there, who is appointing who and who is in the office, that kind of thing. I don't want to discuss that yet. Maybe that one I will discuss with Mr. Coley separately to understand more the thinking behind it. But for now, you cannot create a body without funding.
And this is what has affected the Copyright Office.
You cannot.
The same thing.
This is
Yes.
And that's why you asked the question.
Thank you,
and I
Mr.
think
Chair.
that was not answered.
Now, to address that problem raised by Kaba in terms of the financial provision, that's why I'm suggesting what my boss here is making a new proposal that we have it as an office under the Ministry of Justice. If that happens, we are going to rely on the budget allocated by the Ministry of Justice. You're no more going to be worried about the independent budget allocation for the agency. This is why I was making the suggestion that let him now move a motion that the section 3 to be amended to say that be an office created within the Ministry of Justice, and delete subsection 2 to say that shall serve as a body corporate. You delete that. Now it will be in order if that is the approval coming of the.
That's our intention, really.
And then the other one raised by Kaba, I think it's a good idea to have a cabinet paper being submitted. But again, I am very sensitive around that. Cabinet papers are confidential documents. So it will be important to assume that once the ministry submitted here by the minister, we assume that it has been approved by the
It's going to be tabled by the same minister.
and bring in the cabinet paper.
But looking at
Let me
They are to scrutinize.
let me address Mr. Bite.
yes.
You may not submit the cabinet conclusion itself, but you would at least say that cabinet has approved so and so. Why? Because if your minister comes and cannot defend his own bill because cabinet has not approved it, you are going to have a problem. The minister is going to have a problem because how is he going to inform the president about something which they had not approved? You understand what I'm saying? And for part 2, I think there is a lot of drafting that has to be done. Whether it's going to be under the Ministry of Justice, I think you can look at the Public Finance Act. This is how the Accountant General's department is created. That's already a particular way of doing that. You can do that first. But I think the whole of it will have to be reworked. Even the immunities of employees. Why do you need immunities of employees? They have immunity under the Constitution. There's a section which protects civil servants for that. You have a lot of issues there, and the administrative portions, organization and structure, this kind of thing. But like I told you, you would have to discuss it with them to understand more. Because the Registrar General is already a position. The Office of the Registrar General is already a position in the Ministry of Justice.
Yes,
It's there. It's there already. So what are we... So even you would have to have transitional clause to say that Registrar General is now the... What happens with the position which is already there? It's in the estimates also, under the Ministry of Justice. So are we going to have 2 Registrar Generals? Or, okay, you want to remove that post from the ministry, that kind of thing, you understand? They have a lot of implications on the drafting.
Okay,
I think the first thing is to agree that it should be under the ministry as cabinet has suggested.
Again, I also agree with you. And Mr. Bide, you have mentioned that let him move a motion or something like that. I don't think it will be binding for him to move a motion to make an amendment for now. And again,
you can do that.
okay, fine.
You can move here.
And again, if you check part 2, the interpretations, again, the register name is not interpreted, or there's no meaning of the register. And actually, we have passed many bills where each position could interpret what the meaning of that particular thing, whether the register or the minister, you understand? But I've not seen those things in the draft. I don't know where the draft.
Registrar General, you mean the Registrar General?
Yes.
It's there. No, it should be there. Minister.
Yes.
The minister is there.
Well, I've not seen
it. The minister, because if you say the minister responsible for justice,
yes.
Proposals,
Yeah.
This is not a justice matter. So that's why I think I understand the drafter say the minister is responsible for the administration
of this act.
So that is why you see at the back it is brought by the Minister for Justice, so that you know who they are talking about also. At the objects, so objects and
I want you people to guide us through, you know. You don't lacunas, you understand?
No,
that is just
for them bringing or trying to defend, might be the other drafters. But being your experience, you don't guide us through, whereby we will not have any loopholes in for amendment and sort of things.
If I may comment, your permission, you know, this subject matter is very diverse, right?
So things that has to do with the ministerial functions that are created by the president. And the president actually tells you that this particular minister is responsible for this particular subject matter. So in that case, if the subject matter falls within the purview of that minister, that minister will be responsible for the administration of this particular law. So you cannot actually say that minister responsible for justice. Now, if at all, at a particular instant, the Minister of Justice is not responsible for that particular subject matter, there will be a constraint. So this is why we leave it as this. Whichever minister is responsible for that particular portfolio will be responsible for the administration of this particular law.
Yeah.
Yes.
Yes, Mr. Quinn. In fact, I mean, you mentioned some things here. That is the local, parameters, the Senegal, like Kaba.
Yeah.
They have it as
Yeah.
Yes. So I don't know whether that actually is part of, they consider it part of their law in Senegal, because we also have things in Gambia that are not captured, like the king libas, the Mboro.
Yes. That's where they start. If you have a law on it, then we can go for it. So for us, that's this is the first time we're having these laws. So once they're finalized, then the people ready to sponsor, offer some technical assistance, and then we do a study in the Gambia. So we don't talk with Mbor, King Liba. In fact, we're thinking of Ebe, but I don't think Ebe will fulfill, because if you say Ebe,
it's Gambian.
It's a Gambian. But some will tell you Sierra Leone. So it's contentious. So
we have our Baobab, we have the Mono, we have
the Mono, the Churo.
Yeah, but it's not only so Baobab is found even in Senegal. But the unique taste that comes from that Baobab from Gambia. If it is maybe a particular region of Gambia has this unique thing. So it's not every product that is found in Gambia, but the quality product, because it comes from that region of Gambia. That's when it can qualify.
Like the King Liba.
King Kiliba from Nyomi or Kia?
Jara.
Maybe it could be unique. But once we have technical assistance and study, then because what we need to do, you have to test it, like people from different background, then you boil King Kiliba from Nyomi, Kiang, then you tell them, taste this one. Are they the same? They tell no, this one has sour taste, unique, this is good, I like this. So it's like, and if it is common to a lot of people, then they say this one is unique. That's how it is done.
I have a question for Mr. Cole. Under Section 8, these offices that are listed here, which ones are actually existing right now? These offices that are listed in Section 8, which ones are actually existing right now?
Section 8 is national treatment. Section 8 or 7, you mean? 6. So we only have we have Registrar General, we have Deputy Registrar General, we have Registrar on the Property. So the D is not found. The Minister of Justice.
D is not found.
No,
but
found.
The rest are there.
Huh?
The rest are
there. Yes, sir.
Are you going to change the name?
No, we have to maintain the name. That's how it's called. Some call it his portfolio.
I was trying to clarify which offices
Registrar General
are presently in the
Yes, sir.
Except I think D is with NCAC.
Yes. In fact, they don't have a registrar of they only have copyright officer. So that means if you're gonna occupy this position, you need to promote him if he's the right candidate. He has to be a registrar, so that he'll be responsible for copyright and related rights.
Yeah, because I don't think we would also like to send people home.
No.
Simply because
we are going to add more staff.
Yes. Harold, I want to come in if you will permit me.
What would be your thinking in line with having this intellectual property as an autonomous body without, taking resources from the consolidated? Don't you think you can have resources to operate the intellectual property in the Gambia without?
I think for now, because it's an expensive office. It's an expensive office, so it needs to be planned. That means still be housed at the ministry, but the equipment and other things, if you should move, become semi-autonomous now, to be a challenge. But because we don't want any interruption, we just want to continue as we are. They just come, we move as an office, and that's it. Things go on smooth as if nothing happens. We will not even have a single day interruption of service. But if you have to be autonomous, then they say, okay, the act is passed, you move. When are you going to have the allocation? You are now going to the decision making, appointment of, maybe chair. So it's a process. But when we stay now, if we stay, then it will be continuity.
Yeah.
Okay.
Mr. Gole,
yes, sir.
I think as we progress, we should be equally privileged to understand the dynamics. I have carefully listened to you and considering the references you gave us, more especially with other countries that are currently implementing the bill. And it seems from your own explanations, there have been successful stories around other countries who are established as a semi-autonomous body with the IP. So for me, I think we still need to look at the aspect of what we are doing, and I believe it wouldn't interrupt the progressive work that has been ongoing. That is just one aspect. We can leave that one side. Now, I want to shift, because you know me, I'm from Su, Janjambure. So I think it will be also important to really cater for local communities or locals that are equally participating in the creative industry. For example, the community I come from, we have a unique culture, that is the Kankuran. And apart from the Kankuran, I think we have a lot of, sites or artifacts that can be related to IP. How are we going to protect the interest of those local players in the industry? More especially looking at one provision you have, which said the establishment of an intellectual property tribunal, which you said is a new law that is coming in because it was missing in the previous laws. How do you intend to ensure that the local populace also get to understand this particular material or law as to a guiding tool? Because I understand years back NCAC were trying to engage the regions, because I can recall maybe 5-7 years ago, I sat in one or two of the activities where they have been talking about copywriting and also trying to involve local communities to also take ownership. But then I think it seems there is still a lot more that we can do. How are we going to protect this local?
For local, like I said, there's a regime of payment of royalties, provided whatever that copyright-related right, the cultural thing, the money from that community, of course, should be paid. But for this folklore, our law provides it's owned by government of the Gambia, so we can have a regulation to say whatever payments are made with regards to government folklore, because so long as it's folklore in the Gambia, it's owned by government of the Gambia, not the community per se from Janjambure. So whatever is received in that regard, percentage will be paid to the community. So that's how, that only means we can support the community. Maybe this GI too, this GI of course it will benefit the community, but as far as this creative industry aspect is concerned, it's owned by government of the Gambia. And government of the Gambia too also we may have a regulation to say a certain percentage should be paid to the community. As far as this tribunal is concerned, the tribunal is mainly with regards to opposition. The mandate of the tribunal is mainly opposition, because like if you file an application, okay, the law requires that it should be published for public knowledge. Whoever thinks, in fact, you are not entitled to own that right, they can oppose. So because judiciary too, I tell you, if you, sometimes internationally they ask for the statistics in terms of our laws, in terms of enforcement, because it's of interest to these investors. They want to know whether, in fact, you've been invested. But if you go to the judiciary, if I tell you how many intellectual property cases that we have, they're just few. Currently, we only have 2 that I am prosecuting. So previously, we had a few cases concerning this cable network But for some reason, after 2016, it was terminated. We entered the knowledge. Because people were just using this network thing and then cable. Because the owners of that copyright, they were in Qatar, but the office is in South Africa.
Yeah.
They wrote to us to say, you know what, in your laws you can enforce, even though, but you have a law provision that you can stop this infringement. They are using our network from here, selling it to people in Gambia. And this is our right. And also there was this Canada agent, Mr. Tal, who had a similar thing, who was doing a similar business. They're taking his customers because they're able to use the network from South Africa and selling it here. So his business was going down. They were not infringing on his right, so he came to us and said, you know what, can you do something about it? Even though my rights are not infringed, but they're using the international network that they're not supposed to do. So, they contacted these people, they wrote to us as a ministry. So that's why we too use the police to empower on them. So that is the situation as it is. So eventually we're able to desist. So as far as the tribunal is concerned, it may also hear, issue of dispute to say we have, we are entitled to this percentage payment, but it's not done. But for the tribunal is mainly for opposition. In the event that, in fact, people, their rights are published and someone else thinks they're entitled to be registered. So they come to us because of the capacity that we have. We make the work easy because the first court of instance is the High Court. So if you go to the High Court and they find a challenge understanding the IP issues, it's a technical area. So and it's multifaceted. So unless you study and then have hands-on, you may not really grasp it. And before you write a reasoned judgment, you need to understand. So as a first instance, when we have a tribunal, we hear it and then give our reason for agreeing or disagreeing with the plaintiff or so. And then if it's appealed, then they will have the copy of the judgment before them to say why the tribunal is saying this or the other way, so that they agree or don't agree. So it makes the work easy for them.
Chairman, just a second to finalize that. I think something is just missing. Mr. Kode, what I'm just trying to reach at here is, because you said in this in this draft bill, is there any provision to protect those local communities? Because you said it here just now that some of these rights would go to the government, like the folk bill you have talked about, or the folk laws you have talked about. Can we have a provision wherein some of these local communities can be protected and equally they can see themselves in the picture? Because for me, for example, it wouldn't be fair. You come to my community, take an object from my community, you making money out of it, and I cannot benefit even 5 or 10% of that proceed. For me, I think that is more of ripping of our communities. Because we have a lot of communities that are rich in culture or whatever, like what they have done to the Kiankas some years back through NCSA when they were kind of trying to retrieve some, how do I say, some artifacts that were dug, I think Kiamando or whatever. I have been there some time back, just to avoid some of those things. Because you go to some of these communities, you realize that they are very rich in culture, in heritage, in history, in everything. And sometimes, researchers will come, do certain researches, take certain objects from them, go away with them, and this community still remain to be poor.
You can give an example, even the Freedom Tree. There's some people who are taking care of it so that it will still remain where it is. It has been fenced just near the police station. We call it Freedom Tree. When any slave who runs and touches it, you are free. You are free from slavery.
As a heritage.
As heritage. So I think those things, I think they need to benefit.
Yes, but generally, like I said, it belongs to the government of the Gambia. But in fact, we can have a provision.
No, we know everything belongs to the government. Maybe even we are government material. But again,
we can have a provision to that, on that, to say, certain percentage should be given back to the community. So that can be done.
That's to be considered. Because most of these camp grants, it's not like people don't tie themselves like ordinarily. Because you must be, at least naturally, you must be somebody who is there that wisdom, that knowledge, so that they try to as a Kankuran. Because in a local, you want to be somebody who are gifted. Because not every human being can be tied as a Kankuran. So if those ones are not encouraged, they might not take it as a trade anymore. They prefer to go and look for other trade where they can survive. But if they see that there is a trade for them, they will even try to inculcate or to train their younger ones also spiritually to become Kankuran experts and so on, future. But if there is no benefit, they don't even bother.
Yeah. So this right is there for performance. You know, performance right is there. It's there. Performance right is honorable. So I was saying the performance right, like this Kankuran he mentioned, is there. So whoever the performance and people who do the video, they have their own right. Alright. So that means even if you sell, there's a percentage for the Kankuran, the performance, the dramas, and they have their rights. You understand? But all these they have their distinct rights. This one, the one who sing the song, the one who dance, the one who did the, like the artists who do the promotion, and the people who now do the music or the phonogram, they all have their rights. So what you do is, like, before you do that, they're supposed to have a contract. That is affecting a lot of even our musicians. You are the singer, I am the producer. We have this thing right under the law. But unless we agree, because if I don't sing, you will not produce. If you sing and if I produce something that of low quality, it will not sell. Yes. So we all have our rights. So what they need to do is to have this contract, to say, this is my right, this is how much to pay me. In the event we cannot resolve, this is how we part. We resolve our dispute. So the law is there. It's in the performance right and all that thing. But if it is community owned, that's what I mean. If it is folklore and the community owned, like storytelling. Yes, storytelling. So all these are this intellectual property, and it's all in the law.
Okay. You are satisfied?
No,
okay, Mr. Police.
Satisfied. The only thing I want to say is I think it's important Ministry of Justice take us to first.
We will still have okay, Mr. Police.
I have a question. As I noticed in the objects and reasons clause that the copyright and related rights are being administered by the National Council for Arts and Culture under the Ministry of Tourism and Culture. What happens to the staff of those institutions, that institution, NCAC, when you merge the administration of the different intellectual property rights, and there's no savings clause for their positions in this?
What happened? We intend to move them. It's like 3 of them, 2 ladies and 1 gentleman. Yes, so we intend to move them. In fact, it's catered for in our manpower. But
I'm saying the bill itself does not say so. So it means if the bill comes into force, so they are redundant.
Yes. So going to be staff of the justice, instead of now tourism.
Exactly. That's the intention.
That's an interesting one.
They just three of us.
That's on PMO.
Just in relate to what I just want to take you back. You relate to the question, the similar one. Because as you said, the copyright was dormant at the NCAC.
Yes.
What was their position?
Then it was Mr. Jallo, Omar.
What I'm saying here, the reason why it was dormant, unfunctional, and what was their position when you consulted about moving it? What was their position? And the reason why it was dormant?
It was dormant because of, like I said, it was then it was Mr. Hassum Sisa was the only officer there. So his office was not functional. Eventually, it was Sheikh Omar Jallo who was there. So they have limited capacity because they only concentrated in the issue of culture and arts. That was their focus, and not copyright and the So previously, in fact, they had issues concerned about moving over. But when we started that concert in 2015, they were happy with it. They said they don't have any concern. So they're moving.
So their position, they are in consent with moving.
Yes, moving to minister.
But the question is, who is happy? The employees or their employer?
In fact, for the management.
The management are happy to
manage
their staff.
Yes.
Yes, they are all in consent.
Yes.
They are only concerned of moving.
Yes.
And secondly, did you consult the private sector or institutions when you were drafting this thing? Because all what I've seen here, these are government institutions.
Yes, the private sector.
And we have not seen any private sector indicated in your write-up that you have consulted them.
Okay, maybe
like the music associations or whatever.
In fact, they were part of the consultation process that was done by or supported by EU. The project that Jibril Bar was doing. So in fact, they were the major stakeholders during the two validation process. So all the associations were involved, and in fact, they are aware of. They are looking forward to the coming into force of this bill. They were involved. I mean, as far as private sector is concerned, the association, they are all involved. They are part of the validation, and then the GCCI too. So all the stakeholders.
UNESCO is an international body, but I think there's a body within the Gambia that's taking care of the heritage and NATCO. Where they consulted also.
Yes, they consulted. In fact, they were part of the second validation. Mr. Jaju was the representative. A gentleman from Katong. Mr. Jaju, yes.
Okay. All right. Yes, Honorable Kola.
Yes.
Can you introduce yourself?
Yes, thank you very much. Good afternoon or good morning. Good afternoon to everyone, and I'm apologizing for coming late. Anyway, what I want to know is about the bill is that we all know that IT is it's a cross-cutting, area that has to go everywhere, and is there to support our development. So I want to know exactly, because when I go through the bill, I'm not seeing how IT is going to support this. I don't know whether you understand what I mean. That is IT.
Technology.
Exactly, technology.
Yes.
Is going to support. Every endeavor nowadays has to lean on IT for effective, functioning and efficiency. So that's what I mean. If you can correlate to the IT and this, what we are doing right now, how is it going to support? How are they going to support the job? Because I believe we need IT in this crusade.
IT is relevant as far as this bill is concerned. One is the area of patent. Right, the area of patent. If you come up with any innovation that is new, in the whole world, you qualify as as a patent. Utility model, if it's less innovation, then you qualify as a utility model. So ICT and also copyright too. Copyright too. But if you have any code also, if it is like a programming and it's written down in a tangible form, it can be registered as copyright, literary work. So as far as that protection is concerned, there's protection. And then also encouragement, because of course ICT now, that's the trend. Okay, people are knowledgeable in ICT and then coming up with something that is beneficial. If it qualifies, so depending on the quality, it must fulfill certain threshold. It must meet certain threshold before it can be protected as a patent. So as far as that area is concerned, is catered for in the bill.
I've seen some of the place also here called technological protection measures. What do you mean by this?
The technological protection measures means like if you have like copyright, and then you put it on the internet. Now this law is saying that you should put in place measures to protect it. All right. So anything, the slightest attempt by any party to infringe, because you cannot even, it's not every material that you access on the internet you can download and sell. No. It's copyright infringement. People think whatever is on the internet is free. No, that's not the case. So these measures are in place to say that, in fact, if you have certain measures to protect your work and someone infringes, try to get them and use them, then the person has committed an offense.
Yes,
Part of my question was answered was asked by you by the stakeholder consultation. Okay. But I still go to clause 8, national treatment 1. Like it says, the act shall accord the nationals of the other member states of World Trade Organization treatment no less favorable than that it accords to its own nationals. with regards to the protection of intellectual property rights. I need to be enlightened.
This is the principle, it's a universal principle that is found in Paris Convention, the TRIPS, and and a lot of treaties that require that Gambian, if we have a law, all right, and then we have other nationals, maybe a Senegalese resident in Gambia, you cannot discriminate between a Gambian and a Senegal in terms of for registration of certain rights.
Okay.
If a Gambian, if a Senegalese is resident here and is entitled to patent protection, we cannot say no, because you are Senegalese, we cannot do that. You cannot register, go back to Senegal and do it. No. So long as they have, like legal status that is proper, you cannot discriminate between Gambians and other non-nationals. Yes, that's what it means.
Yes,
yes, yes. We are also talking about enforcement. I know we will review the bill a lot because I think enforcement is important. How do you generally intend to do an enforcement of this particular?
One is to build the capacity of police, because before matters are prosecuted, you must have good, investigation, whatever, and evidence gathering. So one thing is to build the capacity of the police, police enforcement unit, and then also have that collaboration with other agencies, because investigation or enforcement is not only limited to police. And in fact, the GRA, cross-border, if people import infringing even goods, the shoes, there are a lot of infringement going on in Gambia. If you tell, if I should, there are a lot of things, even the shoe, you have Nike, but fake Nike from, not from the proper, owner. Maybe, yes, a lot of, fake, substandard work. Yes. There are a lot of things that we are lacking, but sometimes they tell you, look, if you should say no government should wear genuine Nike, Nike, of course, come up with, if you are producing, products, don't use other people's mark. You come up with your own name. But why would you use Nike when in fact it's not a genuine
That's
Nike?
why you can see Nike,
yeah,
or you see the brand
exactly, Adidas.
Yes, they make some.
If you go to the market today, if we have to enforce the law, or we are going to shut down all the businesses. Because if you go to this, if it is cheap clothing, people use Nike, Adidas when they just fake Adidas, not from the. So if we have to enforce, but we cannot enforce to the letter. The limited way, we do our best. So first thing is to build the capacity of our institution to be able to do that, and maybe create awareness. Number one is awareness is important, but we tell them that this you are infringing. And intellectual property is equally like stealing. People tell you like when I use this, I don't have the means. It's stealing. In fact, the intellectual property is maybe more valuable than the physical property that you are selling. All right. So we want to do a lot of initiative to combat, to ensure that our rights are effectively enforced.
So the clauses in okay, maybe we'll get to that, because I was going to ask, I know most of the clauses are also Gambian. Like I say Gambian, people that are directly looking at Gambian things.
Yeah.
We'll get to that. So
Okay.
we'll get to the content.
Okay.
I think even in this weaving, there are certain trademarks of this weaving. If you one from Ghana, this one is from Ghana.
Yes.
The one from Guinea, this is from Guinea.
They are registering it.
Yes, I think we need to engage also our local ones in Gambia, because there was a time when we are on our oversight visit at Kawaka, we went there, and they were very passionate to at least to be associated with one of the government institutes to register them, so that they can have a trademark whereby this one is Gambian. When you see it, yes, it's Gambian product.
So things like this is what we are looking for.
Yes.
Because there are projects, once we have the law, WIPO can support it.
Yes.
So especially for communities, if they can come as an association and prepare something of quality, they can process it and then export it to
That's what they are looking for. They need that support somewhere from the government side, so that at least they can have a unique brand.
So that is always found in that area of Gambia?
Yes.
Sometimes because of their knowledge, the way they do it very well.
Weaving of that type is found in URL.
So we can agree.
They have them in Guinea, but Now Guinea has specialized on their product. The moment you bring it here, you will know that this from Guinea. The Mali also, the Mali one also, if you see it here, this is from Mali. You can see Ghana. Ghana also have their own product and Kenya. I think those things can be. Okay. Without any.
Yes. I think we can have. We can follow here. But then you can do the conclusion. But I was going to tell. I don't know whether part of your stakeholders, the Gambia Writers Association, the Gambia Music Union.
Yes, they are. All the associations are.
Okay, maybe as stakeholders, but not they are not part of the council.
No, not the council.
Okay, good.
The council, we had Omar, we have a representative of National Center for Arts and Culture, Mr. Jawara. Yes, Senna. Yes, Senna. He was not here. He's part of us.
We'll engage them.
Huh?
We'll engage the stakeholders.
Yes, yes.
I have a final question.
Okay.
The rational document, there's mention of a tribunal being proposed. I don't know whether Mr. Kohli would like to share his experience or knowledge about how they are set up in other countries that you form part of your study. How is it composed? Who are the chairpersons and the like?
Yeah, in fact, this is something that we discussed. All right, the composition generally could be an outsider. Someone provided a person has a technical background, all right, and then comprised of any member identified by the office. Because sometimes it's a right, you don't have a standing on an established, you know, it could be an ad hoc anytime. Because for this year, we only had 2 oppositions. So in some cases, if you have to establish a tribunal, then we're paying them, it's a problem. So that's why now we suggest in other countries like because the composition like make it an odd number and the registrar general. Alright, some think the suggestion, but if you have other stakeholders like the National Council members who like based on the area of expertise, because we all did our masters in IP but specialized, or did our we have thesis in different areas. Even with regards to trademark, I know who to contact, to say, what do you think? Can we have a committee to decide on this issue? And then decide. That is the experience.
So in those other countries
like even
Sierra Leone or Ghana,
Nigeria have.
And Nigeria,
yes.
Do we have the heads of the offices as members of the tribunal or as ex officio members?
Ex officio.
Ex officio. And chairing them?
Yes.
Like in which country?
Like I think Sierra Leone.
Sierra Leone. The Registrar General is the chair of the tribunal.
Not it has a nominee. Yeah, but it's on ad hoc basis.
It's on ad hoc basis.
Ad hoc basis. Yeah.
But it's not reflected in the bill that it's on ad hoc basis.
No.
Do you want
so it's
it
like
full time or ad hoc?
Ad hoc should be ad hoc, because if you have in a year only maybe one opposition proceedings, that will not take you even 2 days. Especially when the parties have their registration and the document. Just 1 hour sitting, you can tell who is right, who is wrong. Because it's like a matter of what documents do you have. Did you register or not? You did not register. Or you have goods that are in use, it's fine. Then you progress, they agree that you are the one entitled to this mark, and that's the end of it. Thank you.
How does the Registrar General, who is the head of the office,